Kenny MacAskill.
Pleasure to serve under your chairmanship, and as with others, I congratulate the member for bringing this debate. I take the view that employment law should have been devolved at the outset and should certainly be devolved now. It is, in fact, an omission, and I think it might be worthwhile considering why it is that it hasn't been done to date, and indeed why, even when we've reviewed it through Calman, through Smith, and indeed other junctures, change hasn't been taken. Some who opposed it at the outset have learned hard lessons and have correctly moved on. Others will have to explain, as has been asked by recent members, why they still continue to be intransigent. It does seem to me to be an omission from the Scotland Act, but it always was, the Scotland Act, an act that lacked cohesion. It was neither federalism nor was it logical. Matters were reserved that arguably had no logic, and indeed matters were devolved summarily. That has left us with a situation where the economy was devolved as such, but not the fiscal levers which can operate it. Criminal justice, in which I was privileged to serve as Justice Secretary, was devolved, but not firearms or narcotics. Show me a jurisdiction in the world in which firearms and narcotics aren't the basis of the criminal law or the breach thereof. We had the situation at the outset where euthanasia was devolved, but abortion was reserved. We even had the absurdity that Antarctica and powers over it were devolved, but foreign affairs were reserved. I don't know anybody in any political party that ever sought Scotland to have a say over Antarctica, but the member wishes to contribute.
But just to add a very pertinent comment today, when further devolution was being considered for Wales, water was to be retained in London and sewage was to be devolved.
Yeah. Yes, well, I think that shows the illogicality of, indeed, the current devolved setup. We obviously have seen changes. Some have come through Smith, some have come through Salmon, some have come through in other ways. We have air weapons now devolved, even although firearms are reserved. We have the drink driving limit devolved, although road traffic remains reserved. And indeed, abortion has since been devolved to join with euthanasia as powers within the Scottish Parliament. During my tenure as Justice Secretary, the Scottish Tribunal Service was established, and it became the Scottish Court and Tribunal Service, having previously been the Scottish Court Service and the Tribunal Service. At the head of the Scottish Court and Tribunal Service sits Lord Carloway, the Lord President, the very pinnacle of the judicial system in Scotland. And yet beneath that we have tribunals being operated and run in Scotland, and yet many of the aspects that are most fundamental to them, the law and the legislation and indeed the regulations, are reserved to Westminster. That makes no logical sense and indeed is absurd. In the tribunals actually will see more people, more citizens appear before a tribunal than ever appear before a court of law. And yet what Scots are finding is that the court, or the tribunal rather, that they're most likely to go to seek to see if recompense or change or whatever it is, some aspect of justice, they have a situation where it's led by the senior Scottish judiciary, but in fact the organs and levers are controlled. But that moves on. It should have been devolved, and it should be now, because it is essential. We have a new Prime Minister who has laid down already where she sees things going. I have to say I think that is fundamentally wrong. We cannot be going backwards. I was reading a book recently about a radical MP called Joseph Hume, who had actually served in Middlesex, Montrose, actually served in Killarney, not in Wales, but he came to fame because he opposed the Combination Acts. The Combination Acts were legislation that didn't outlaw striking. They outlawed the right of workers to organise. They predated laws that came in that allowed workers to come around, that came in through Keir Hardie and others. What does that tell us? It tells us that that wasn't in the 1930s. That was in the 1830s. Joseph Hume was opposing the Combination Acts that existed before Queen Victoria came to power. And yet we have an incoming Prime Minister in 2022 who's talking about ruling out strikes, who's talking about attacking the fundamental rights of workers to organise. We're going back not to the 1930s, but to the 1830s under this new administration, which takes me on that whether or not employment law is devolved, enough is enough. The Prime Minister will have to recognise that whether it comes from law changes in Holyrood, as it should, or whether it comes from actions in defence to legislative changes here in Westminster, Workers ain't going to take it anymore. The changes to be brought in have already seen those, the likes of the RMT, Unite, CWU, out on strike, not simply because it's the right about wages. It's also about terms and conditions of employment, because we know with the fundamental RMT dispute, it's not simply the wage that they're seeking, not the figures that are bandied about of 55,000, because the average RMT worker gets nothing like that. It's about the fundamental terms and conditions, the reduction in workers, making those who remain work longer, reducing the terms of their safety. All of these. Enough is enough. It's unacceptable. I conclude by saying, Mr. Chairman, that employment law should have been devolved at the outset. It should most certainly be devolved now, and irrespective of that, the fight is on. Changes may be brought in by this current administration to try and change and use the powers that they have here, but they will be opposed in Scotland. They'll also be opposed across the country.